Avoid these costly mistakes when filing adjustment of status in 2025. Welcome back to USA Alert Zone, your trusted source for the latest updates on U.S. immigration news, policy changes, and visa strategies. Today, I want to talk about some critical mistakes that applicants are making when filing for adjustment of status, AOS. These mistakes are not just small technical errors. They can have life-changing consequences. Why does this matter so much now? Because under current USCIS enforcement trends, if your adjustment of status application is denied and you are out of status, you could receive a notice to appear, NTA, and be placed in removal, deportation proceedings. So, in this video, we're going to break everything down step by step so you can avoid these mistakes, understand your options, and take the right approach from the start. The high stakes of adjustment of status. Generally, when you're in the United States, you must maintain valid non-immigrant status at all times. You cannot have worked without proper authorization during this entry. And you must remain in status while your adjustment of status application is pending unless an exception applies. If your application gets denied and you are no longer in valid status, USCIS can and often will issue a notice to appear, starting your removal case in immigration court. This doesn't mean your situation is hopeless. There are often legal remedies, but fixing it later can be stressful, expensive, and time-consuming. Mistake 1. Filing employment-based AOS after losing status. One of the biggest mistakes I've been seeing recently is people filing for employment-based adjustment of status after they've fallen out of status. Here's how it typically happens. Someone had a valid visa status, like F1 or tourist, but overstayed. Later, they secure an approved I-140 employment-based petition. They assume they can file for AOS because they have an approved petition. But here's the rule. If you want to adjust your status based on an employment-based petition, you must have maintained valid non-immigrant status the entire time you've been in the U.S. This process is extremely fact-specific. Overstays, status violations, or unauthorized employment can make you ineligible to adjust status from inside the U.S. Pro tip: employment-based immigration is complex. Always consult an attorney who specializes in employment-based cases. Family-based immigration rules are very different, and a misstep here can cost you your green card eligibility. Mistake 2. Misunderstanding family preference categories. Another common error is misunderstanding the difference between immediate relative petitions and family preference petitions. Here's the breakdown. Immediate relative petitions, faster and more flexible. Spouse of a U.S. citizen. Unmarried children under 21 of U.S. citizens. Parents of U.S. citizens, if the child is at least 21. In these cases, you can still adjust status even if you overstayed or worked without authorization. Family preference categories, longer wait, and stricter rules. F1. Unmarried sons and daughters, 21 plus, of U.S. citizens. F2A. Spouses and children of permanent residents. F2B. Unmarried sons and daughters, 21 plus, of permanent residents. F3. Married sons and daughters of U.S. citizens. F4. Siblings of U.S. citizens. For these categories, if you're out of status, you generally cannot adjust status in the U.S. unless you qualify for an exception. For example, if you entered with parole and your parole is about to expire, but your parent, a U.S. citizen, petitions for you while you're over 21, you won't be able to adjust in the U.S. through that petition because your priority date won't be current for years. Mistake 3. Filing too early or too late in preference categories. Timing is everything. Example: a permanent resident petitions for their spouse who is in the U.S. on an F1 student visa. The I-130 gets approved, and the visa bulletin shows the date will be current in 4 to 5 months. If the spouse files for AOS before their F1 status expires and they've maintained their visa terms, they may qualify. But if they wait too long, overstay, and then try to file after losing status, they'll likely face a denial. Another example: someone here on an H-1B, a dual-intent visa, has far more flexibility. H-1B holders can typically remain eligible for adjustment while maintaining their status. Mistake 4. Misjudging tourist visa overstays. Here's a scenario I've seen repeatedly. A permanent resident petitions for their fiancé who's visiting on a tourist visa. They get married after 90 days and file the I-130 petition. They wait until the priority date is current before filing AOS. By that time, the tourist visa has long expired. Even if USCIS issues a work permit while the case is pending, the adjustment of status will likely be denied because the applicant was not in valid status when filing. Solution: the permanent resident should naturalize first. Once they become a U.S. citizen, the spouse falls into the immediate relative category, where overstays no longer bar adjustment. Mistake 5. Entering without inspection, EWI. If you entered the U.S. without inspection, without a visa or parole, you cannot adjust status based on a family-based petition, unless you qualify for an exception. The key exceptions are Section 245, if you were the beneficiary of an approvable petition, employment or family-based, filed before April 30th, 2001. Parole programs. Being granted parole after entering without inspection, such as military parole in place or parole programs for nationals of specific countries like Haiti or Venezuela. U visa holders. If your U visa is approved and you have an I-94 issued afterward, you may be considered inspected for AOS purposes. Without these exceptions, your only path is usually consular processing abroad, which may require a waiver for unlawful presence, a process that is complex and risky. Why legal advice is critical. The immigration system is complicated, and every situation is unique. Filing incorrectly can result in denial, trigger deportation proceedings, cost you years and thousands of dollars. Even if you don't plan to hire an attorney to handle the full process, at least schedule a consultation to make sure your strategy is solid and you're not overlooking any red flags. Extra warning: I-130 petitions alone can trigger risks. One more point that many people overlook. Even if you only file an I-130 petition without filing for adjustment of status, if the beneficiary is unlawfully present, USCIS may still issue a notice to appear after the I-130 is adjudicated. This is why it's so important to have a clear plan before filing anything. Final thoughts. Always maintain valid status unless an exception applies. Understand the difference between immediate relative and preference category rules. Don't rely solely on advice from friends or the internet. Every case is different. Timing is critical, especially when dealing with preference petitions and visa bulletin movements. Seek qualified legal advice early to avoid costly mistakes. Thanks for watching USA Alert Zone, and don't forget to like, subscribe, and turn on notifications so you never miss an important immigration update. See you in the next video.